Private equity professionals have a language all their own. They reference EBITDA multiples, which is just a fancy way of saying net profit when you add back partner salaries, and waterfall distributions like someone ordering coffee. Law firm partners will react in one of two ways. Either they'll nod their heads like they know what all this means and then quietly disengage, or they'll be mesmerized by the valuation and upfront money and assume the rest of the deal is just standard. Nothing is standard right now. This is why a plain language explanation will help law firm partners understand the 7 pillars of legal MSO: management services organization, transactions, valuation, upfront capital, compensation, governance, capital deployment, cultural alignment, and the cash out at the end. Let's start with valuation. Valuation is typically expressed as a multiple of EBITDA. In the current market, legal MSO deals often fall between 4 times and 10 times EBITDA, with 6 to 8 being the average. The mistake many attorneys make is treating this multiple as the headline and the conclusion. It is neither. A firm receiving 6 times its true profit margin can get a much better deal than one receiving 8 times, depending on the deal structure. Valuation is just the starting point. Here are questions partners should ask their advisors and attorneys. After I get the check, am I still the leader of my firm or just an employee? Will I watch some of my longtime and loyal staff get fired for efficiency? When the time for the truly big money comes, will we be left holding pennies compared with the millions the MSO will rake in? Valuation is the shiny object. Deal structure is the difference that determines whether you maintain your control, your firm's culture, and a truly beneficial cash out at the end. Next, let's consider the pillar of upfront capital. Upfront capital is not a gift, it is an exchange. You are monetizing a portion of your future earnings today, and the buyer is making a calculated bet that they can grow the enterprise and capture a return that is multiple times higher than their investment. This is where terms like preferred return, which is the minimum return the investor receives before others participate in the upside, and waterfall structure, which is a tiered system dictating how profits are distributed, with the MSO usually sitting at the top of the waterfall, enter the picture. A deal can be structured to feel generous at closing, but when the big payday comes, partners can find themselves wondering why so little trickled down into their account. On to pillar number 3, partner compensation. Many MSOs are actually embracing the eat what you kill model, recognizing that for rainmakers, the primary motivation remains direct alignment between effort and reward. However, the shift occurs in the structure of that payout. Sophisticated deals are moving toward hybrid models where the core compensation remains tied to the individual's book, while a secondary growth bonus is tied to firm-wide EBITDA. There are also deals where partner compensation actually dips, but is more than made up for through distributions from the MSO. The precarious pay plan is the aggregate pool. If the MSO requires you to pool your compensation with the rest of the firm, you are effectively underwriting the performance of your weakest partners. The golden rule in MSO negotiations: never accept an aggregate bonus pool. Demand that your compensation remain tethered to your specific book of business and your personal performance. Once your pay is buried in a firm-wide pool controlled by PE, you cease to be a partner and become a line item expense. Of course, like everything, there are exceptions to aggregate pool structures wherein they can be perfectly acceptable, especially if there are only a few rainmakers or if the firm itself is the brand. Again, it comes down to having the right attorneys and advisors at your side. Let's turn pillar number 4, governance. The Management Services Agreement, or MSA, is the contract governing the relationship between the law firm and the MSO. If the fee structure in the MSA is tied directly to legal fees or firm revenue, it can quickly cross the Rule 5.4 line into unauthorized practice of law or unethical fee splitting. Lucien Pera, ethics partner at Adams & Reese, said this on the subject: "There are 2 sets of ethics issues in the services agreement: complying with the ban on sharing any attorney fees with a non-lawyer, and not giving the MSO control of the law firm in any way that violates the ethics rules." Fee structures that tend to work include flat periodic fees for all services, different flat fees for individualized services, like marketing or HR, or fees based on the costs of each of the MSO's services, plus a percentage markup. Next up, pillar number 5, capital deployment. Once legal MSO deals are finalized, the conversation shifts to what PEs call capital deployment. In other words, what they're going to invest in your firm to help it become more profitable. This usually starts internally with upgrades to systems, tech, and AI, for example. Then they'll invest in acquiring smaller firms or bolt-ons and rainmakers to add to your firm. This is where deal structure counts. Some MSOs provide committed capital or funds contractually allocated for growth. Others require bureaucratic approvals or earnouts, such as requirements you must achieve in order to earn capital investments. If the MSO requires permission to sneeze, you are no longer running a firm. You are the restaurant manager of a franchise. Michael Kelly is the lead legal MSO partner at Parker Poe, and he has seen the difference between deals where equity partners are on the board of directors and where they are relegated to employee with a nice title. He puts it this way, quote, "The critical questions from a regulatory, ethics, and business perspective are, do attorneys preserve control over the pure legal function and legal services to clients? And do lawyers continue to have a meaningful stake in the growth strategy of the firm/MSO? If the deal is structured properly and equitably, the answer to both will be yes." Let's explore pillar number 6, capital alignment. PE firms want standardized KPIs. Law partners want to do what has made them successful. If the deal is not structured well, you don't get synergy, you get culture clash. If this is not addressed in advance, rainmakers will head for the exit. The solution? Use a dual-track governance model. Centralize the administrative slog, HR, vendor contracts, tech, and so on, to reap economies of scale, but keep the lawyer stuff, like case strategy and partner compensation, under firm control. Define these rules of engagement early and create a board or other vehicle that gives partners real authority. If you don't draw that line, your law firm's identity will dissolve faster than a sandcastle during high tide. Finally, let's talk about pillar number 7, the second bite. The second bite of the apple refers to the opportunity to monetize your remaining equity when the MSO is sold. In theory, this is where the largest financial upside resides. In reality, this is where attorneys risk getting left with considerably less than they imagined. The second bite is not guaranteed, nor is an amount proportionate to your equity ownership. For example, if your portion of the MSO is worth $1 million at signing and $10 million when it's sold, you might only receive $4 of that $10 million. Why? Negotiated deal structure. The MSO might be structured in restrictive caps or excessive terms that entitle them to a portion of your equity at the end of the deal. This is why deal structure is more important than valuation or upfront capital. The legal MSO industry is still in its early stages. That means that right now, firms are getting the best deals they will ever get. At least the firms that are smart enough to hire the best advisors and attorneys. Those who don't are getting the worst deals because they are paying attention to the shiny objects, valuation and upfront capital, while the MSO is taking control over autonomy, culture, and the massive payouts at the end.